Here we go. Well, welcome everyone. Hope you can hear me all right. Thanks for joining us this afternoon. My name is Tracy Simons. I'm the Executive Director of the Silver Cross Foundation. We're the charitable fundraising arm for the hospital. I want to commend all of you for making this effort to get your affairs in order. And if the pandemic has taught us nothing over the past few years, nothing else other than to be prepared and for whatever it may happen in the future. So I bet that everyone joining us today has have people or charitable organizations in your lives that you want to take care of after you're gone. And hopefully Silver Cross is one of those organizations you may be considering. If you've already included Silver Cross in your estate plans, thank you. We're delighted to have you as a member of our Legacy Society. And if not, we have 3 local experts today who will show you how to do just that. And best of all, it will cost you nothing during your lifetime. They voluntarily serve on our Silver Cross Foundation Board of Directors, raising philanthropic support for our hospital. So let me introduce them to you really quick. We have Heather Vaughan, who is a partner with Vaughan, Jaworski, and Preston here in New Lenox, specializing in estate planning and elder law. Nick Tyrrell is a financial advisor with Edward Jones in Joliet. You may recognize his name as his dad, Jim, works here at Silver Cross. He's the manager of our sterile processing, keeping all of our surgical instruments clean and safe. And lastly, joining us today is Kathy Miller, who has her own State Farm insurance agency here in New Lenox for, I believe, over 35 years. So a long time. And in addition to life insurance, which she's going to talk about today, she also provides a variety of other insurance for personal and business use. So over the next hour, we're going to share simple ways that you can help you make a gift in your will or trust, reduce your taxes for your children and your heirs, delivering extraordinary gifts to Silver Cross and other charities, and maybe even convert surplus life insurance coverage into a legacy gift. We're also going to cover retirement fund contributions, charitable remainder trust, and donor advised funds. And of course, we're going to have time at the end of our program for questions and answers. As I mentioned, today's presentation is being recorded, and we will send it out to you later this week, along with a link to a complimentary estate planning guide to help you get started. And if you'd like to have this mailed to you, you can go ahead and enter your address in the chat. You can direct it to me, Tracy Simons, and I'll make sure we get that out to you. And also throughout the afternoon, if you have any questions, just put them in the chat. We're going to hold all those till the end and try to get through as many as possible. So with that, let's get started. So just kicking it off, I wanted to share a little bit about our foundation here at Silver Cross. As I mentioned, we're the not-for-profit fundraising arm here at the hospital. We raise money for new facilities and programs and services to enhance the expertise of our caregivers and, of course, to continue providing safe, accessible care for all of you, our patients in the community. It's important to note that every dollar that we raise here at Silver Cross stays here at Silver Cross. We're an independent community hospital, so all the money we raise does not have to go to other states and other hospitals. It all comes right back here to provide care for you. And I'm proud to say that since 1988, we've raised over $55 million for our hospital. We leave no stone unturned. These are all the different ways that we raise money here at Silver Cross. Some of you may have participated in some of our special events. We also work with businesses to raise money. We accept grants and have all different kind of giving opportunities. So today we're going to focus on planned giving, and that's the column in the beige, second column in. And I will turn it over to Nick, and he's going to talk a little bit about our approach, and then we'll get going.
Sounds perfect. Thank you, Tracy. I first want to say thank you to you and the foundation for allowing Heather, Kathy, and myself to speak this morning. To all of you that joined in, I hope certainly you get some information out of this. Plenty of good information. I do want to mention, as long as that list was that Tracy just talked through, it certainly is not an exhaustive list. There's so much detail that goes into everybody's estate plan. We know everybody's family is a little bit different. Everyone's financial situation is a little bit different. So at the very least, we hope you pull a couple of pieces of information away that may interest you, may sound like something you'd want to do, and certainly look to work with a group of professionals to put that plan in place. And that is really the key for the three of us on this call today, Heather, Kathy, and myself. A team is the key. Make sure that if you are seeking to put a robust plan together, it includes all of the right professionals, not just a piece. So we put a list here. Certainly, many will think of the attorney when they talk about estate planning and think about something like a will or a trust, but it is just as important to make sure that it fits with your overall financial plan. So working with an advisor, financial planner, an insurance agent like Kathy, and certainly, I know we don't have them here on the presentation today, but you also should pay attention to any tax consequences as well. So including a tax professional or a CPA is extraordinarily important. So as we talk about taxes, it feels only natural to pass it on to Heather for our next slide to start to talk about some of the basics of estate planning.
Okay, thanks, Nick. Thanks, everybody, for attending. The new year, so we usually have some new numbers that we have to be aware of when we're talking estate planning and taxes. Can hardly believe it's January 31st already, but here we are. So at the beginning of the year, some new changes went into effect with regard to estate tax. And so the present 2024 federal estate tax exemption is $13.61 million per person. So if you pass away and you have $13.61 million in your estate, or over $13.61 million in your estate, you may be finding yourself subject to federal estate tax. If you're a married couple, it's essentially a joint exemption of $27.22 million now. But there's some portability tricks in there that are a little bit more complex for our discussion today, but things to keep in mind. Everybody's heard of the rule, or I get a lot of people that say, hey, I can give $10,000 per person without tax consequences. Well, that figure is not 10,000 anymore. It hasn't been for some time, but it is the number that everybody likes to stick with. And the current number as of 2024 is 18,000. So gifting 18,000 to a family member or and friends, you do not have to file a gift tax return. There's no tax consequences to that. If you go over that amount, you might have to. And speaking of gift taxes, the new limit for that is also $13.61 million. It's tied to the federal estate tax exemption. So technically in your lifetime, you could give away $13.61 million without estate tax or gift tax, but you'd also have to see what your value of your estate is when you pass away. So they work in conjunction. And something that I think is overlooked regularly, because everybody focuses on the federal taxes, is Illinois itself has its own estate tax exemption, and that is $4 million, which is pretty low. It used to track with the federal taxes, but now they've decoupled, and it's $4 million, which between some real estate and some retirement accounts, you could easily get close to that. So to avoid that, it's a really good idea to consider some estate planning. So with that said, let's get into the basics of estate planning. First question is always, what is it? So we all have an estate. This includes your car, your home, accounts, any type of asset is part of your estate. When you pass away, you can't take your estate with you, but you can plan for what happens to it. And I am a big fan of planning because I'm a little bit of a control freak. So I want to make sure my plans and wishes are in place. So why do we do estate planning? If you have specific wishes that you want to take into consideration when you pass, and you have very, direct wishes on this is what I want to happen with my assets, it is very important to consider getting an estate plan in place. Many people will come to me and say, oh, if I don't have a will, I'm worried that the state of Illinois is going to take my property. Thankfully, that is not the case. However, the state of Illinois can decide who gets your property. And that is always contentious because it could be very different than what your actual wishes are. It's even different for married couples, and they're always surprised when I tell them, if you're married and you pass away, half of your estate under the law should go to your spouse and the other half goes to your kids. And most married couples feel that everything should go to their spouse. So just one very basic difference in general opinion versus Illinois law. If you don't have an estate plan, you also could risk significant taxes. You could risk probate court, which we'll be talking a little bit more about in the future. There's legal fees and court costs that could really be involved without a proper plan in place. And I always like to just make a side note before we go into the documents is once you actually have a plan and you've cooperated with your team of experts and professionals, you should always revisit it. And I say generally every 3 to 5 years. The law changes, life circumstances change. You want to make sure your wishes are still accurate, what you put in place several years ago. So keep that in mind as well. So I want to talk a little bit about the different documents to consider. There's a variety of different estate planning documents that can be put in place. And as Nick expressed earlier, each family has their own dynamics, their own facts. And so the goal is to cater these documents specifically to your situation and your wishes. So not everybody needs all of the documents or certain types of documents, but this is why you should meet with your team to discuss what's the most appropriate for you. In general, though, when we're talking about an estate plan, we're talking about powers of attorney, which are interestingly generally only good during your lifetime. In Illinois, we have a property power of attorney who an agent's appointed to make financial decisions for you if you're not able to. And then we also have a healthcare power of attorney. And this appoints somebody to make medical decisions for you if you're not able to do so yourself. I basically tell everybody 18 and older, they should have those documents because they're that important. You know, if something happens and you're in an accident and can't make decisions, or you get dementia, or something happens where you can't control what you want in life, this allows you to appoint a trusted person that you have faith will make the decisions the way you would want to. If you don't have these documents and you became disabled and couldn't handle your affairs, we end up having to petition a guardianship court to get a guardian appointed. And that is, I like to refer to as probate court for the living. It's not pleasant, it's public, it's costly, and you might not get the person you would want in charge of your assets and healthcare decisions. So again, back to having some say-so, better to get it in place beforehand. So in addition to the powers of attorney, which terminate at death, then we're looking at what do we do to handle the things after I pass away. So generally the next document to consider would be a will. And this document operates at death and it distributes your assets to family, friends, charities, whomever you want to leave your belongings to. A key note about wills is that it only governs assets in the decedent, the individual who passed away's own name. So the will does not address joint accounts, accounts with beneficiary designations on them, or accounts in trust. It's only anything in the individual's name only. A very important piece to doing a will is if you have minor children, you can name who you would trust to be their guardian if something happened to you. So this is very important for a lot of parents of young children, or even an adult child with disabilities. You can name someone that you trust to help take care of that person when you're no longer able to. Something to note about the will, if you pass away without a will or with a will and nothing's in trust, you're probably going to end up in probate court. I have a lot of people who are confused about whether the fact that they have a will avoids probate court. So a lot of people will come to me and say, hey, I've got a will, we're good. And I'll tell them, technically, no, the will still requires you to go through probate court. It just spells out who you want to get stuff and instead of letting the state make that decision. So if you're looking to avoid court involvement and lessen fees and delays, it's generally You're wanting to consider probably a living trust or a revocable living trust, as they're also called. And the trust can hold assets during your lifetime for your benefit, which you can control. And then when you pass away, it operates as a will and distributes out the assets in the way that you want them to go to and to whom you want them to go to. With the trust, we have a little bit more flexibility. We don't have the court involvement generally, and you can minimize taxes. You can include a lot of tax planning. Usually there's no court, there's no court fees, and much less legal costs involved. There's a ton of different trusts that exist out in the world: special needs trust, irrevocable trust. And again, that's probably a higher level of discussion than we have time for today. So today I was just kind of focusing more on revocable living trust, and then I will be discussing charitable remainder trust in a little bit as well. But having those documents kind of spelled out, let's talk a little bit about bequests. And the main reason what people think about for estate planning are bequests. It's who you're giving your property to when you pass away. And the bequest can be a distribution or a gift at your death. So that's usually kind of everybody's focus when we're talking about wills and trusts. Who gets your property when you pass away? And I would just say a lot of people have very opinionated wishes on this, and that's fantastic. And we can cater to your wishes in these documents. The key to make sure is getting it done right. You can certainly do it yourself, but I have seen that go awry in so many ways that I would just recommend, if you want to make sure it's right and your wishes can stand any challenges and things like that, you really want to talk to an attorney to get it done correctly. We have a lot of cases where we're called in to try and fix these things. Sometimes we can't, sometimes we can. But what I'll tell you is it's often very costly and causes a lot of hardship and hard feelings in families. And the key is you don't want the attorneys to get your estate. You want the people that you want to benefit, your beneficiaries, to get the estate. So having it done in the correct way is the best way possible. And lastly, with the bequest, people are always concerned about, of course, providing for their family, but they also have philanthropical wishes as well. Something to keep in mind is you can plan for your family and charity. They're not mutually exclusive. So you don't have to make a choice between the two. And we'll talk some additional ways on how to do that. Tracy, I think you would have an example.
I do. Yeah, thank you, Heather. So I just wanted to share with you, we received lots of bequests from wills and trusts here at Silver Cross. And here's a good example. So some of you may know the Kurtz and Vanna families. They're very involved in the New Lives community. Back in 2017, they gave a transformational gift in celebration of 40 years of friendship to the hospital. They owned a paramedic service, they owned a funeral homes, and they wanted to support Silver Cross. A few years later, Tom and Michelle gave another transformational gift to support our new NICU, which we named after their triplets. It's called the Amy, Matthew, and Jay Vanna NICU. And they did this. Both these gifts were part cash, and most of it is in their estate gifts. So when the families pass away, Silver Cross will be the beneficiary of those gifts. So something that they wanted to do during their lifetime, but also takes care of us well into the future so that Silver Cross continue to be around for many, many more generations.
Thank you, Tracy. That's a great example. I want to touch a little bit on probate court and then estate tax. Everybody's heard of the probate court horrors. We've articles in the newspaper about it. We have friends and family who have gone through difficult probate cases and litigation. And as I said, in Illinois, if you pass away and then there's any assets in your name only with no joint owner, no beneficiary, and not in trust, you will have to go through probate if the value exceeds $100,000. And this is regardless of whether you have a will or not. So the only real way to avoid that probate court process is through properly funding a revocable living trust, which can hold the assets for you. Probate court, again, is a public proceeding. There's court filing fees. You must have an attorney involved. And one of the key issues is the probate matter has to stay open for at least 6 months, giving creditors the ability to file claims against the estate. So there can be delays, there can be expenses, and all of that can really be streamlined with revocable living trust. So again, if you want to stay out of court, best to probably consider some trust vehicle instead of just a plain will. All right, so I talked a little bit about the new tax numbers. I want to go into a little bit of more detail on estate tax. So one of the big reasons to do estate planning and more complex planning is to minimize or avoid taxes. No one likes taxes. And we've all probably heard of estate tax, but sometimes in the news and the media, it's lovingly referred to as the death tax, which is very depressing. But it's the estate tax, and it, as I said earlier, the new exemption amounts are if you have assets over 13.61 million, then you would be subject to federal estate tax over that amount. The range of the tax on that amount can be 18 to 40%. That is huge if you are at the higher range of that. And as I also said, Illinois, not all states have estate tax, but our state does. And Illinois has a $4 million exemption. So if you pass away and you have assets over 4 million, then you have an Illinois estate tax. And the range for that is about 0.8% to 16% taxable rate. So again, not a pleasant thing. Beneficiaries are not happy to find out that a good chunk of their money that their family member wanted them to get goes to state of Illinois or federal government. So one of the ways we can avoid this is we can do some planning to protect that. Something to keep in mind is generally if we have a married couple, the spouses are able to transfer money to each other with an unlimited marital deduction. So maybe not any taxes on the first spouse to pass. But if the surviving spouse receives all the proceeds and then doesn't do any planning, then there could be taxes on the second spouse's death. So it's important to kind of get these plans in place while both spouses are capable, and then we can minimize the taxes and maximize what the family actually gets and the benefit. And some people might tell me, oh, well, you know, this seems like some big numbers. I don't really have to worry about that. There was a time when there was no estate tax, briefly for federal, and they keep changing the rules. So unless there's anything that changes with the law sooner, in 2026, the estate tax federally is going to drop to 6.8 million. That's a lot less than the current exemption. So it is important to kind of revisit your documents once you have them in place and to plan for the what ifs. You know, we don't know what the estate tax is going to be in the year that you might pass away. So we want to figure out the best strategies to minimize the taxes as best we can now and keep an eye on it every couple of years. So one of the other great ways to minimize estate taxes is also considering including charitable donations or charitable bequests. There's a variety of ways to set those up, and you can help minimize the taxes and still benefit charities. So with that, I'm going to turn that over to Kathy, who can talk a little bit about beneficiaries and insurance and ways to provide for charities.
Thanks, Heather. So I'm going to start a little bit with it, just life insurance 101. Why you really want to have it your whole life, because there's kind of a misconception out there. I talk to a lot of people and they feel that once they hit a certain age or a certain point in their life that they really don't need any life insurance anymore. So some of the things we'll go over today to tell you why you do want to keep it and plan for it along the way. Make it part of your plan all along the way. So there's a couple different types of life insurance. There's term insurance and there's permanent or cash value whole life insurance. They both serve a purpose for sure. In general, when you're younger, you have growing family, need to replace income, things along that line, then term insurance fits best in people's budget. But as things change, you really want to look at having some permanent insurance or cash value. And it serves for many purposes. Number one, you're really kind of building up your own, I hate to say bank, but in a sense, your own bank. You're building up living benefits by that. That's money that you can use how you want. And if you use it, borrow it against your policy during your lifetime, then it's deducted from the death benefit. But the importance is that it's something that'll last your whole life. And unlike term insurance, it ends at a certain point. This will last forever, and you don't have to keep paying on it forever as it grows in value. So there's really needs to have it your whole life. And some of the things we're going to go over now is going to tell you why you'd want to have it. So some of the things, one of the biggest things about it is that life insurance is tax-free to the beneficiary. So you've got, like Heather was talking, the estate taxes, or you've got retirement accounts that have, that are, of course, taxable because they're tax deferred. So they're going to be taxable as you withdraw the funds or as they're left to people. The life insurance is not taxable to the beneficiary. So that is really a huge benefit, and why you want it as part of your whole estate as well. So one of the biggest things to keep in mind too is the beneficiaries. Beneficiaries are so important, and they will make and not just on life insurance, but on many of the things that we're going to be talking about. Because if you don't keep up with that, then I've had situations where ex-spouses have been named when people have been remarried. That doesn't go over real well. And just situations where, they might want to leave it to a child. And if the child's a minor, and they only list that without listing a custodian, then again, that's a problem, because then it has to be brought to court versus being handled through the policy. So some of the things I'll touch on of what, how you want to set it up is, the most common, like it says here, is the spouse. And that's what I've run into, I'd say, last couple of years, definitely, is that, like I said, people say, well, do I really need the coverage? And then if I do, well, my spouse doesn't really need it. So at that point, I tell them, well, why wouldn't you want to maybe leave a legacy? If you don't feel they need it, then leave it to somebody else. So you might want to leave it to children or grandchildren, or a charitable, like Silver Cross or charitable charity. And like Heather mentioned earlier, it doesn't have to go to one place. It can be split up amongst. So it's just having the beneficiary designation accurately established. So for children, again, if they're minors, so let's say you want to put your grandchildren on there, because you figure, well, your kids are on their own, take care of it, but this was a legacy you want to leave to your grandchildren. It's just important to have a custodian listed on here. And unlike the will, or it could be similar, unlike it, but like Heather mentioned, in the will, it'd be the guardian. And this could be the same person for a child, but it could also be just somebody who might want to handle the finances for them. So it could be two different people. You could have a guardian who take care of the children or grandchildren, and then you could have a financial custodian. They're often the same, but sometimes people are like, what, they're horrible with money, I don't want them being in control. Well, then that's fine. Just pick somebody that you'd be comfortable with to handle the finances. But again, that's how we would set up the beneficiary. Estate, I'm going to say estate taxes is huge. So like Heather was discussing, as far as having the federal estate tax. So think about this. It doesn't apply to the spouse. But if you have life insurance, that would be very beneficial for the children, because then they'd have that money to help pay some of those estate taxes. So it's not all coming out of it. So it's just, again, something to supplement it. Then as far as you can, you can use your life insurance too for, Nick's going to go into this in more detail later, but say required minimum distributions. You know, you get we talk to people often, they have the RMDs and they're like, I don't really need it, but I have to take it. So we've been able to help in the form of either life insurance policy on themselves that again is being left tax-free, because you don't want to take something from a qualified and make it put into something else that's taxable. So, you know, either help themselves, or if they're in a situation they're not in good health, then they could actually have a family member that they could be the owners of the policy. Their money, you know, they're using the money to pay for it, but they're the owners of the policy. So they have control over how it grows and everything, but then use somebody else's life basically to be able to supplement that. So, and then, you know, obviously, like we said, a charity, that is huge as far as, again, you're feeling like, you know what, my kids are fine, not worrying my grandkids, they're taking care of it. But why not a charity? Why, you know, something that you've supported, or something, you know, that you feel is very important, that certainly helps them and it helps you, you know. So so that's another great use for life insurance. So I just would like to encourage everybody to get out of the mindset that I get to a certain point, I don't need life insurance. That's honestly farthest from the truth, because the more our assets grow, the more you actually do need it. So, and the advantage, you know, I'm sure we have all age groups on here, but, you know, the advantage of starting it when you're young is that you can, you know, I'll usually tell people, get as much as you possibly need, because that you can always change it over to cash value or whatever later, but you might not be able to get it later if you run into health issues. So, so get it going early, get it started, but know that there's many uses for it. And don't think that, okay, I hit a certain age or my kids are in college, I don't need this. It's really not true. That you want it to last your whole life, and there's just so many benefits to doing it that way. So as far as this is just, I'm not by any means a CPA, so a disclaimer is talk to your tax advisor. But this is just giving you an example of, like we said, you know, Heather's going to get into a lot more detail in the charitable remainder trust. But this gives just an example of how it could be beneficial having life insurance for to present to a charity or charitable remainder trust. And then and this, again, just some of the things I've already discussed. You can choose to give gifts of income every year to children, grandchildren, or a charity. You've got the gift tax exclusion. And then the next page is just gives an example. This is just, like I said, I'm not going to go through it in great detail, but it's just telling you that what kind of tax savings you could have by making a charitable gift, and how it would be beneficial. And again, life insurance to cover this would be beneficial for everybody involved. With that, we will hand it over to Heather to get into the charitable remainder trust. Heather's muted.
I know. It wouldn't allow me to unmute. So thank you. Thanks, Kathy.
You're welcome.
So I just want to touch on charitable remainder trust. Basically, this is a tool in the toolbox that can be used when you do want to benefit charities, but you're also maybe wanting to make sure you can provide an income stream for your life or someone else's life. So it's beneficial to the person and also the charity. The way that they are generally set up is that it provides an income stream to you or a loved one or another entity. And then when that person passes, the remainder would go to the charity. There are two types that we see. It gets a little bit of alphabet soup, I like to joke. So this is the CRAT, which is considered the charitable remainder annuity trust. And there's also the CRUT, which is called the charitable remainder unit trust. So I'm going to start with the CRAT, the charitable remainder annuity trust. This you could basically set up where it would be a fixed distribution amount as the income stream. The distributions are usually about 5 to 15% of the fair market value. If you go this route, you can't add money or additional assets into the CRAT. But you could set up another one if you wanted. So with that, if it's set up, you're getting distributions each year of, let's say, 10% of the fair market value. When you pass away, the balance would go to the charity. If you set it up under the CRAT, you have to start taking the income payments once you actually set it up. So again, depending on what your specific situation is, this would be something to talk about with financial planner, your attorney, and your CPA to figure out what would be the best tool to use. So the CRUT, which is the charitable remainder unit trust, is based on a percentage of the trust. So the income that you're getting is a percent of the trust, and the value can go up and down. So usually that would be around 5 to 50%. And of course, it's tied to the income of the trust at that time. The payout is generally computed annually, and you can then add funds to it. So there's a little bit more flexibility if you wanted to contribute more funds in the future. The benefit too with this one is you could also delay payments into a future date. So you don't have to start taking that income right away, which might be more beneficial, let's say, if you're already have significant income and you're in a higher tax bracket. So there's a lot of benefits to the charitable remainder trust. Maybe go to the next slide. I'll discuss those. One of the biggest benefits is you have security of an income stream during your life. Everybody likes to provide for charities, but there's always a concern, am I going to have enough? Or is this person in my family going to have enough to live off of? So one of the great benefits is you get an income stream during your life, but you can still satisfy your charitable intent and minimize estate taxes. There are certain ways you can set it up so that, I'm usually looking kind of at funding highly appreciable assets to these types of trusts, because let's say the real estate that you purchased was $50,000, now it's worth $3 million. That's a significant amount of appreciation, which if you ended up putting into a charitable remainder trust, would not have to pay the capital gains on. So we're looking at stocks that have appreciated significantly, real estate that's appreciated significantly. It's a great way to provide you still an income stream, but also provide for the charity and minimize those taxes. Once they're established, you really can't change the beneficiaries or the payouts. So you do want to take your time in setting them up and making sure that they're exactly the way that you want them. And while you could be the trustee, I would highly recommend against it and having somebody independently in charge of that trust, just to make sure there was no running afoul of the charitable deduction, which is a huge reason for doing so. I think that these provide that flexibility and really should be considered by anybody who's looking to have some flexibility and comfort in their situation and also still provide for the charity. When you set up the payment, you can actually set it up to pay for that person for life, or it can be under 20 years. So you're trying to ensure that there's still balance to go to the charity when you should pass. But really good tool to consider if you have that charitable inclination. And with that, I will shift it over to Nick on retirement accounts, or actually Tracy, sorry.
That's okay. Thanks, Heather. So I just have one more example to share. So this is a great example of a charitable remainder trust, and we have a couple volunteers who were here at the hospital for 15 years. They helped out in our surgical waiting room and our discharge lounge with a lovely couple, Elmer and Tilly Wilhelm. And back in 2004, they let us know that they had included us in their estate plan. So in 2015, when both members of the couple, both Elmer and Tilly, passed away, we received $100,000 from their living trust. And then they had set it up so that the remaining funds would go to Tilly's sister, and upon Tilly's sister's death, Silver Cross would receive a third of the rest of the estate. So Tilly's sister just passed away this in 2023, so this past year, and so we're waiting to get the remainder of that estate. But it's in the 6-digit estate, so we're hoping that those funds that Elmer and Tilly so wanted to help out Silver Cross with back in 2004 will allow us to be able to buy, more equipment here at the hospital, expand our services on campus, provide education for our employees, et cetera. So just, a wonderful thing that they did, almost 20 years ago, that's now going to benefit the hospital today. So with that, Nick, you're up.
Sounds perfect. Thank you, Tracy. And thank you, Heather. I'd imagine in a lot of your cases, as is the case for most, a large portion of the assets that you hold may be in retirement accounts. So picture a 401k, a 403b, a 457, or IRAs. With the hundreds of families that my office works with in the greater Joliet area, thousands across the country, a lot of times you'd be doing yourself a disservice if you ignored those retirement accounts as part of your estate planning, because they can become such a big part of your overall assets. So a few things I want to touch on when it comes to your retirement accounts is some changes that we've seen in the last 3 or 4 years that, if you weren't aware of, it can make a huge impact on how your loved ones receive part of your retirement assets. Okay, so I want to start with the old options. So if I had an IRA or a 401k and I had listed, let's say, my children as beneficiaries of that account, the old rules would allow them to do one of 3 things. They could take a lump sum. So if they're a beneficiary of my IRA, they could take it all out of that inherited IRA. They would pay income tax on that total amount. And then once that tax is paid, they can do with those dollars what they please. They could take a 5-year deferral, which essentially means in this case, my children would have 5 years from the date that they receive those dollars to totally empty that inherited IRA. So they could split those dollars up over 5 years, meaning they could take roughly 1/5 out every year for 5 years. They could wait all the way till the end of 5 years and take it all. And the last option was a stretch IRA, which for a long time was a huge benefit to our kids or grandkids. If they received that IRA or 401k as a part of your estate, they got to hang on to that account, and they would only have to take a small required amount every year over their lifetime, which compared to the lump sum option might mean, as opposed to them taking $1 million out this year and paying income tax on it, maybe they were taking $12,000 instead. It was a huge, huge benefit to your kids or grandkids to be able to avoid that extra taxation. At the end of the day, we want our kids, grandkids, loved ones to be the benefactors. We often don't want Uncle Sam to be that extra benefactor at the end of it all. So as of 2020, there was a law passed called the Secure Act, and the Secure Act changed those options. Okay. They still can do the lump sum or 5-year deferral, just like the old options. But instead of the stretch IRA, the only other option now is a 10-year deferral. So I want to use a quick example to articulate why this is so important. Let's say I have one child and $1 million IRA, and that child is listed as the sole beneficiary. If my child were to receive that $1 million inherited IRA, and it was all pre-tax dollars, at a minimum, my child would be adding $100,000 a year to their income. Now, if they're already working and maybe earn 150,000, and then they add an extra 100,000, it could mean a large portion of what's given to them through my estate now is in a higher tax bracket. Okay, so just knowing that rule change exists is incredibly important from the standpoint of planning for how your assets are received by your loved ones or a charity when you're passing on retirement accounts. You have to pay attention to not just the total amount that you're passing on, but also how it would be received by those that are getting it. It may mean there's an opportunity to do a little bit more Roth conversions or have conversations surrounding maybe funding life insurance. I'll have a nod to Kathy here, funding life insurance to help pay for some of the extra tax that might come as a result of it. There's a lot that can go into planning, but the single most important thing is just having that knowledge initially of how it's received to start to work with a professional to decide what the best next steps are. So if you could switch it to the next slide for me, Tracy. So as I talk about changes that just happened, it also is important to talk about changes that are currently going on and will continue to go on going forward when it comes to retirement accounts. So they had also just passed what is now called the Secure Act 2.0. We are in the process, even at Edward Jones here, of working through the language of some of these changes. A notable one that could be the case, it's not confirmed yet, but I'll say it's likely. That 10-year payout rule, as it's written right now, means that your beneficiary would have a little bit of flexibility on how they take money out of that inherited IRA. So as it stands right now, it kind of says if they wanted to wait 10 years and take it all out, they could. If they wanted to wait 3 years and take nothing because they're about to retire and then take the remainder over 7 years, maybe that makes sense. There are some potential changes that may require that a portion of this is taken out every year, a minimal amount required every year. And then beyond that, they would decide how they take out the remainder. So things to keep in mind again, changes we at this point would assume will go through over the next year. And so as we're thinking about this year and beyond, it's something you certainly want to pay attention to. On the next slide, I'll talk about some upcoming or continued changes to required minimum distributions. So this is usually when we did this presentation in person, I asked for a show of hands to say, is anybody currently taking an RMD? And I'm going to echo what Heather said. Sometimes it sounds like I'm speaking in alphabet soup. I apologize. And RMD stands for required minimum distribution. So if you have any pre-tax retirement accounts, so this could be a standard 401k or 403b, it could be a traditional IRA, it could be a 457. There are rules that dictate once you hit a certain age, you will have to start to pull a small percentage of your retirement account out of that account every year, okay? Oftentimes, the immediate question I get after that is, Nick, what's the amount? And it's a little bit more difficult to articulate quickly, but it's calculated on an annual basis. And it's based on the dollar amount or the dollar value of that account, December 31st of the year prior, and your specific life expectancy. Okay, so it can change every year depending on how the stock market moves or how much money you add to or take out of a retirement account. Okay, for years, the rule of thumb was when I hit age 70 and a half, that's when I have to start taking that small portion out. Now, that has changed due to the Secure Act. It's actually a benefit, in my opinion. We get to wait a little bit longer before you're required to take anything. So if you're curious when that would happen, find your birth date on this graph that we put on the slide. It's important to note that as of 2024, the age is now 73. So if you are turning age 73 this year or soon after this year, know that the expectation is in this year or going forward, you'd have to take a small amount out of your IRA or 401k every year. There are certain exceptions. I'm happy to answer them on a personal basis. As of a birth date of 1960 or later, so this is fast forwarding quite a few years now, they expect to bump it up again to age 75 as that required age. It is important to note, if you miss your RMD, so if you forget to take it out by December 31st, you are potentially looking at a 25% IRS penalty. So it is not something we want to mess around with. It is definitely something you want to make sure you get done and plan for in the future as well. Tracy, if you wouldn't mind. Perfect. So the question at that point often becomes, what do we do with our RMDs? If we have to take them, what are my options? And it tends to come down to three main options. The first is for many the obvious one, right? If I'm already taking money out of my IRA or 401k to help fund retirement in addition to Social Security or pensions, maybe I just need to take that out gradually over the course of the year to spend it. Okay, and that is always the option. You can gradually take it out. You can take it all at the beginning of the year, or if you're like a few of my clients, they wait until December 5th and go, I forgot about that thing. I need to take it out. And we always make sure it's out of there before December 31st. The next option is to invest it. Now, this can look different depending on your situation. But let's say you have this 401k or IRA, you have to take that amount out of that retirement account, but you don't really have an immediate spending need for it. I don't know what I do with it once I take it out. Oftentimes that prompts a conversation with me to decide what other options you have for those dollars. Now, if you take it out of that IRA or 401k, and you pay the tax on it, and you have those dollars remaining, oftentimes it may mean we invest it for a short-term need or long-term need. As Kathy alluded to earlier, sometimes we'll use those dollars to fund premiums for life insurance in order to create a bigger tax-free benefit to your beneficiaries in the future. There's a multitude of ways that we can use those dollars to benefit your overall financial plan. I've seen it used to help fund college accounts for kids or grandkids. The list really goes on and on. It depends on your own situation. The last one is to donate it, which I'll argue is probably the least well-known option, and one that I wanted to make sure people are familiar with. So Tracy, if you wouldn't mind the next slide. So if you were to decide, I don't think I'm going to spend these dollars, I'm already set financially and don't necessarily want to invest them or do any of those other options I just mentioned. If you're charitably inclined, it may mean instead you want to do something called a qualified charitable distribution. We'll add to the alphabet soup with the letters QCD. A qualified charitable distribution would mean, let's say I have a $1 million IRA, I'm over age 73, and so I'm required to take, I'm using random numbers here, $20,000 this year out of my IRA. Well, as opposed to me taking the $20,000 out of my IRA, paying tax on that $20,000 as though it was income, and then taking the remaining dollars and giving it to a charity of my choosing, what you can instead do is write a check directly from that IRA to a qualified charity. Here's my shameless plug, like the Silver Cross Foundation, should you choose. As a result of that, you now don't need to realize that $20,000 as income and pay tax on it. And you get to give to a charity that you probably would have otherwise been donating to on a regular basis throughout the year as well. So it is important to note a QCD you can start doing as early as 70 and a half. So you don't necessarily have to wait all the way until age 73 or in the future age 75. And that, again, is a check that goes directly from an IRA to a qualified charity. It can come from a traditional or Roth IRA. Certainly discuss with your financial professionals to decide if it makes sense, if that's something you're interested in doing. I think, Tracy, I'll pass it on to you just to talk about some examples of that.
Yeah, thanks, Nick. Yeah, so we receive a lot of QCDs more and more every year. You know, they funded scholarships. They've gone to the greatest area of need unrestricted. We use it in all different ways. But here's a good example. So some of you may know Dr. Bunko and his wife, Evelyn. They've been part of our Silver Cross family for many, many years. And when we were starting our open heart program about 5 years ago, Mrs. Coe came to me and wanted to do something to honor her husband's service to Silver Cross. So she chose to give a gift, and we did some name recognition on a sign outside the ICU. We were building a couple ICU rooms at that time. And so she chose to fund that gift from her QCDs from her IRA. So she spread it out over 3 years so that she was able to make the most of her tax savings. So she didn't have to pay taxes on the money from her IRA, and she did use it for something great. So because of her forward thinking, you know, we now have 2 new ICU rooms that they help pay for. So just another way you can use your retirement savings to help out Silver Cross or another charity.
I love it. Thank you, Tracy. I love the real life examples. Up next, I wanted to discuss, speaking of charitable giving, I'd be remiss if I didn't talk about a donor advised fund as another potential option for giving while still alive as part of your overall plan for your estate in the future. Before I dive into that, I saw a few of you taking some notes when it comes to retirement accounts and some considerations. I want to make mention of one thing that I forgot to mention a moment ago, and that is the Secure Act and Secure Act 2.0 also did affect if you have a trust listed as a beneficiary on your retirement account. Okay, this was common practice for many years. I'm saying was past tense because under the Secure Act, if you list your trust as a beneficiary of a retirement account, instead of that 10-year payout, you are potentially reducing it to a 5-year payout under the new laws and regulations. So if that does apply to any of you, it is certainly worth consulting an attorney or financial professional to decide whether or not, even if it made sense previously, whether or not that's a change you should consider going forward as a part of your overall estate plan. So to finish here, another thing I want you all to be aware of is a donor advised fund. So a donor advised fund is a tool for those that are charitably inclined to be able to give, I tend to use the term, not just do good, but do good better while living. Meaning if you are used to giving amounts to various charities on a regular basis, and let's hypothetically say you're giving to these charities, but because you're giving a smaller amount, maybe you aren't quite seeing the tax benefit you would have otherwise hoped for. So you give $2,000, but your standard deduction is well over that. And so you still gave, but maybe didn't see that benefit on the tax side. One consideration you could have is putting a contribution into a donor advised fund. So the way a donor advised fund works, you can see an example of it in the chart on the graph. If you were to instead take a larger sum and put it into a donor advised fund, let's say in year 1, you'd be able to potentially take that entire or a good portion of that contribution to the donor advised fund and use it as a write-off in this year, because it's a much bigger amount and you can use it immediately as a write-off or a deduction. But going forward, those dollars stay in this fund. It is irrevocable, so you can't take them back out. But in this fund, you're able to invest those dollars, let them continue to grow and build up a charitable fund, in which case you are able to write grants on a regular basis to various charities that would qualify. So in this case, you have the benefit of that tax benefit at the beginning, but you also get to gradually see that charitable fund grow and give those dollars out to a qualified charity over time. Now, if that's, if you're already charitably inclined and that's already something you're doing, it allows you to almost create like a personal foundation is kind of the way I think many have thought about it. It's not exactly that way, so I'll put a little disclaimer there. There is differences, but it's a way to start to set up a fund so you can give to charities on a regular basis. Now, in the event that something were to happen to you and you pass away, with a donor advised fund, you can also dictate a steward of the fund who would be able to continue to write grants to charities even after your passing, or can write rules to give the remainder to certain charities if you were to pass. So it's a way to start to give in a little bit smarter way. It also sometimes allows for a little bit of anonymity. It's like saying anemone in the Finding Nemo movie. So if you wanted to give on a regular basis to various charities, take advantage of tax advantages. I'll use one final example. Let's say maybe you've owned a stock over 20 years or 10 years that's done really well, right? You caught that Amazon when it was a $20 a share online bookstore many years ago. Oftentimes, that's another circumstance where a donor advised fund can be a huge benefit. If you were to sell part of that stock now in order to give to a charity, you'd potentially realize quite a bit of gains that you'd be taxed on. If you took those shares and put them directly into a donor advised fund, you'd be able to avoid that taxation and ultimately give more to charities over time.
Okay, so I have one more example here. Frank Margaron had set up a donor advised fund with the Community Foundation of Will County. There's lots of companies you can set them up with. Edward Jones is one, Fidelity, Charles Schwab. We have a local one called the Community Foundation of Will County. And he did it so that he could fund a lot of different charities, including Silver Cross. And with Silver Cross, he used the money to set up a scholarship in honor of his wife who had passed away, who was a former Silver Cross School of Nursing alumni. So over the past 12 years, out of this fund, Frank was able to give us $1,000 each year, which funded a $1,000 scholarship for an employee here at Silver Cross who was, either becoming a nurse or continuing in her nursing career. So kind of a little caveat, like Nick said, Frank had passed away, and his daughter Janet, who's in the flower dress in the photo, she was the beneficiary of that fund. So or the steward of that fund, and she took it over, and now she continues his legacy and Twyla's legacy to continue that scholarship here at Silver Cross. So just another way you can, support Silver Cross and save some dollars. So we're seeing a lot more donor advised fund gifts. And just a quick note that if you do give Silver Cross a gift or any charity from your donor advised fund or your retirement fund, let us know, because when we receive the check in the mail, they don't always indicate who it's from, who the donor is, unless you want it to be anonymous. So if you do want to be able to be acknowledged and get a letter in the mail from us or emailed from us saying your tax savings that you can use when you file your taxes, please let us know that it's coming so that we can put the pieces together and make sure we recognize you appropriately. So with that, just wanted to wrap it up here. A couple things. We have a legacy society here at Silver Cross. We've had one for many years. If you do include Silver Cross in your estate plans in any way, a bequest, life insurance, property, real estate, stocks, what have you, let us know. And we would love to recognize you. We'd rather recognize you now than after you're gone. And on the slide, you can see all the different ways we do that. We also have a donor wall in the lobby, which is pictured here. And these are several of our Legacy Society members. Once again, this is something, for over time. So even after you pass, we still include you as a member of our Legacy Society. Let us know that you've included us in your will or trust or your estate, and so that we can recognize you appropriately and add you to this list. You can just call us at the foundation, send us an email, what have you. And then Nick, this is one of Nick's favorite quotes, so I'll let you kind of close it out here, Nick.
Perfect. So at the end of the day, again, everything we went over today is I'm sure not all encompassing of each of your individual plans and your situations. If there is one takeaway, it's don't let your estate plan end up on the back burner like it is for many. For a lot of folks, it is tomorrow's issue. And so I'll leave you with a Benjamin Franklin quote, which is, if you fail to plan, you are planning to fail. Make sure that you have a plan in place, and certainly reach out to any or all of us with individual questions as well.
Okay, so my colleague Kelly has been kind of monitoring the chat and see if anybody has any questions. If you do, you can enter them in the chat now. Kelly, do we have anything that we need to address?
Yes, we do. Oh, Julie had asked if this presentation will be available again to listen to. And yes, Julie, we have it recorded and we will email it to everybody later this week so you guys can listen to it again or scroll through some parts that you maybe need to have a little refresher on.
Yeah, we'll send out a copy of the slide deck too. So if you want to print that out and pass it on to friends or whomever, that'd be great.
That is all the chats that we have at this moment, Trace.
Okay. Well, if you have specific questions, feel free to call any of us, make an appointment. We'd be glad to help you. And we appreciate you taking time today to learn more about how to prepare for your future. And with that, have a great day. Thank you.
Thank you all.